Vignette 3. Grounds for removal and role of estate trustee during litigation.
So welcome back. I hope that little break helped you. I know it's good to have little breaks during the mediation. I want to see if we can address the third issue that we identified. And Saul, I know that you have some concerns about Emily continuing to be your father's executor and attorney for property, power of attorney for your mom. What's your general position on that?
She's self-righteous and can't be trusted.
Could you be briefer, please? Okay, but how are we going to resolve this? Because is it right that you want her off as
Yeah, my materials are clear that she's got to go. I mean, I think she's probably booked an appointment at Casino Rama this afternoon. So we got to stop the gambling, or we got to stop the money coming out for purposes other than mom. I want mom to be properly cared for. I want mom to have the proper amount of money spent on her. That's not the issue. But the notion of these gifts of $2 million, the transfer of the condo, and spending money gambling, that's completely offside.
Right. And Emily, everyone's in the same room right now. So let's let Saul hear what your position is on this. And as far as staying on, because look, both of you are here because of your mom, right? That's why you're here. You're here. That's
why I'm here.
Right.
That's not why he's here.
Well,
he's here to get money.
Okay, but let's.
Well, you took it all. If you just brought the pillowcase with all the money in it, we'd be done here today.
And that's why I love these open sessions, because they can really get everything on the table. So, Emily, tell me about your view on staying on as the executor of your dad's estate and as the power of attorney.
Well, these roles are so important to me. You know, my mom chose me. She chose me to be her power of attorney. She could have chosen Saul. She could have chosen anyone, but she chose me because she knew I would do a good job. And I have to continue to be her power of attorney. I mean, I want to do it. I know I want to do it. I don't think I can bend on this one. I just can't.
Okay, so let me tell you guys a little bit, just because I've got a little bit of experience in this kind of situation. This is where things really can get expensive, right? Because Saul, you'd have to go and bring a motion to remove Emily, and Emily, you'd have to defend that. And if Saul's right and he can convince a judge
I am right.
Right? I'm sure. We'll really let the judge decide that, of course. That's, the other thing about this, and I know both of you feel that you have the perfect case. No one has the perfect case. And I know you feel you're right, and I know you feel you're right. But you guys aren't the ones deciding. It's going to be a judge, and we often say in this area that, you know what, you might win with 5 judges, and you might win with 5 judges out of 10, but you just don't know which judge you're going to get. So if Saul's wins, then that's going to create a whole level of costs, of expense to your mom. And if we can come up with some way of keeping the cost down but still protecting Saul, you can understand where Saul's coming from. He wants protection. I'm sure you want your mom protected as well. So maybe we can come up with some middle ground on this. What about this, Saul? You should know what's going on with your mom because you have concerns. What about the idea that you provide some sort of accounting to Saul as you go, so that he knows what's going on and he can make sure that no large sums are coming out? He has that concern, and if you were on the other side, you'd have the same. So what do you think of that? Maybe that's great. Why don't you let each other speak first? I like the fact that
well, it's a disaster for her if she loses, because then she's going to have to pay everything back. But starting with the notion of just the removal,
right?
Just that. I mean, this certainly goes against the position I came in, but if it can bring some peace to Mom, because I know Mom knows that we're arguing about this. She doesn't know, she doesn't understand details. She doesn't understand the property. She doesn't understand the accounts. She doesn't understand any of that. But she also doesn't want to see us fight. I know that she's told me that. And when she does see my sister stroll in at 6 o'clock in the morning from the casino and my mom's up, she does say, you know, why are you arguing with your brother? So hopefully, maybe there's a way, like I look to you, but maybe there's a way where we could get bank statements on a monthly basis. And with respect to my dad's estate, I think that my daughter should be paid out her bequest. That hasn't taken place yet. So I'm not quite sure how that would work, whether that comes to me, that comes to my daughter, it goes and paid into court. Maybe you can help us with that. But if we get that taken out of the way so that my daughter has that money that was earmarked for her, maybe there's a way we can find a way with checking the balance here.
Emily, that sounds kind of reasonable to me, that if you're not doing anything wrong, I'm sure you don't feel you're doing anything wrong, then letting him know what's going on is fair, don't you think?
Well, I could provide him with statements, let's say once a quarter from
once a month.
Well, let's stop there for a second. How often do you get the statements? Do you get them monthly?
Well, I get them monthly, but you know, I'm busy, so I can't give him statements every second, but I could compile them every 3 months, and I could give him statements every 3 months. I don't have a problem with this.
Okay, let's break into our separate rooms for a second. I'm going to go into Emily. Now, Emily, what you'll find is sometimes you'll feel that I'm kind of being tough on you, and as tough as I am on you in this room, you can bet that I'm equally tough on Saul in the other room. If you're getting statements monthly, then it really doesn't take much effort to email them to him on a monthly basis. I think that would get us...
he's always changing his email address. Well, what am I supposed to do about that?
Well, why don't we do this? Why don't we come up with an agreement that you can send it to whatever email is his last email, unless he notifies you otherwise. And then the burden's on him to let you know about changes. There are ways to resolve this. I mean, the good thing is, I have the feeling that both of you are here. You're here for Mom, right?
Yes.
And I do believe, whether you believe this or not, that Saul's here for Mom too. And so let's try to figure out a way that Mom is protected. And let's try that. So I think a monthly statement would be reasonable. I think you can do that. Don't you think you could do that?
So just so I understand, so every month I get the statement from the bank, and then I just email it to my brother at his last email address. I don't have to do anything else. Just send him the statement.
Right. And then what we'll try to build in is, what happens if Saul has a question about a cash withdrawal? Because cash is not a great way to take out money. Because
that's what you get at the bank machine. You get cash. I don't understand.
And one of the things I'm really strongly recommending that you do is you get some advice on how to go forward as the power of attorney for your mom, because there's some things that you should be doing that it's going to make your life easier and going to make Saul's life easier.
You know, my mom likes to go to the hairdresser every week. We go every week.
Great.
And she goes to the same hairdresser, and it's like $60 a week. And sometimes we pay cash. Sometimes we just want to pay cash.
Right. Well, I think there's probably a way around that. And the idea is that if maybe the two of you guys can come up with a budget that you both agree with, that I don't think Saul is saying you can't spend money on Mom. He seems to be happy with Mom being looked after and cared for and all of that. It's more a question of making sure that it is for Mom's benefit, right? So let me go talk to Saul for a second. All right, Saul, so look, I think I can get her to the point where she's going to give you monthly statements. And then she did raise a few issues with me that she's allowed me to take back to you. And one of the issues that she's told me to talk to you about is this hairdressing.
She's a nut job.
Okay, but here's the thing. If we focus on the issues today, that's what we're trying to do. This is like a business meeting, right? That's what you got to sort of think of it. This is like a business meeting. We're coming down to dollars and cents here. And if you were running a business, you'd probably want a budget, right?
I think a budget, but while you were away, I came up with an idea. Why doesn't she have a credit card with a max of, say, $2,500? And then that statement will be readily available and will detail everything that she spent the money on.
Right.
And so she doesn't have to worry about going to the cash machine anymore and pulling out cash with indiscriminate amounts. If she wants to pay for something like my mom's, I bet she brought up my mom's hairdresser. Is that what she brought up?
Right.
Yeah, $60 a month?
Yeah.
Or $60 a week, yeah. So if she just paid with the credit card, she'd never have to go to the bank. So it'd be convenience there. We'd have monthly statements, and it would have a limit that she would be able to utilize. And then that way, she could just give me the statement on a monthly basis, and it would itemize to whomever the payment was.
Okay. So, guys, I'm just going to take a break now and maybe turn it over to some of the experts to fill us in on, if we did go the removal point, the way you started, or if you were going to defend it, wanted to stay on, maybe how the law would impact on that and what the experts have to say about that. So I'm just going to turn over the microphone to the panel. And leading the panel, chairing the panel is Archie Rabinowitz, partner at Gowling's. I'm sure everyone in this room knows Archie, and he's acts regularly for LawPro as their preferred counsel. He's a leading lawyer in all of the surveys and works on estate litigation primarily, as well as other things, and we're very pleased to have him, and I'm going to turn over the mics to Archie.
Thank you, and thanks for the intro, and apologize for being late. I know this case cold for a variety of reasons, and I just want to introduce the comments that our panel will discuss under what circumstances a court would entertain an order removing an attorney for property or suspending and replacing them with an estate trustee during litigation or a trustee during litigation, in any event, or an attorney replacement. It seems that from the comments that everyone just heard, that Mini-Me, also known as Saul, wants, at minimum, Emily removed as attorney for property for mother, and also wants Emily removed as an estate trustee, I understand, for their father. And I'm going to ask questions first of Angelique Moss, who is in the middle of the table, and I hope her mic is live shortly. If not, I'll pass mine over. And it seems that Saul believes that his case is a slam dunk, that he has no chance of losing the case. And I'm just going to ask Angelique to comment on what factors a court would look at in determining whether or not Emily ought to be removed as an attorney for property.
Well, generally speaking, hopefully my mic is on, there needs to be two things a court will look at. There needs to be compelling evidence of misconduct or neglect on the part of the attorney, which must be advanced or proven. And the overriding factor is that of what's in the best interests of the incapable person, so in this case, the mother. So Saul needs to get evidence before the court to provide or to prove the misconduct or neglect. And how this is typically done is through an accounting. So an accounting under the provisions of the Substitute Decisions Act. Now, because Saul isn't automatically entitled to an accounting, he must get leave of the court first, and that's under Rule 42, sub 4, sub 6. And the importance of making sure you seek leave of the court in order to do this is set out in the McLaughlin decision, which is a recent decision where leave wasn't sought and then it was denied, the application to compel an accounting by Emily in this case. I would suggest that Saul is very likely to get leave of the court to compel that accounting. And the general test for when a court will grant leave is whether the person has a genuine interest in the affairs of the incapable person, and whether there's a significant concern that's been raised that can be made out with respect to the incapable person or the grantor of the power of attorney's property. So from that juncture, the court may then terminate the power of attorney on its own initiative or on a motion, and that's pursuant to Section 42.7 of the Substitute Decision Act. But what you would have heard through the panel discussion, what was suggested by the mediator, is that these removal applications can be very difficult, and they can certainly be very, very expensive. So where there isn't sufficient evidence to make out a case, there are other avenues that counsel might want to recommend as a first step, and one of those avenues might be an investigation by the public guardian and trustee. Another avenue is to seek directions from the court, and that's pursuant to Section 39 of the Substitute Decisions Act.
And just by way of a follow-up question, Angelique, what evidence do you think someone like Saul would put forward in, given our fact situation, in support of an argument that Emily ought to be replaced as an attorney for property?
Well, he has a number of facts that he can put forward in this case. The first of which is the gifts of $2 million from Mom and Dad's assets. It's a bit unclear which money came from which pool of funds, but they were jointly held funds. So that's self-dealing. He can put that argument forward, preferring her own personal interest to the interests of the incapable. It's unclear, of course, as we discussed in earlier panels, whether Mom had the capacity to make gifts and whether those were in fact valid gifts. So all that evidence would come forward in terms of a removal application. There may be also an argument that the gifts were invalid due to undue influence on the part of Emily. We had heard earlier that she was living with her parents. She had a very close relationship with them. So that might be another argument to put forward. There is an exculpatory provision under the Substitute Decisions Act, though, if Emily, in making gifts to herself, was found to be acting honestly and reasonably and diligently. She thought Mom had capacity to make the gifts, and she was honest and reasonable and did the due diligence before she accepted those gifts. There is a possibility then that she could be exculpated, even if those gifts were found not to be, in fact, gifts. So along the same lines, Emily might be in a conflict of interest position going forward. If the gifts were not valid, then they should be reimbursed to Mom. Of course, Emily might not be willing to do that, certainly having received the gifts. Another issue is the transfer of the Florida condo to herself. This took place at around the time of Dad's passing. Emily's argument was that, well, it doesn't really matter. I get the condo eventually at the end of the day anyways. Maybe she was given advice from a financial advisor in some cases to avoid probate fees. This might have been the best way to go about it. Again, what was her thinking? What advice was she given? There is a problem, in fact, of course, because of the jointly held property. Now, creditors might be able to come and attack the property, and that, of course, is linked into a potential, the suggestion, at least in the materials, that Emily might have a gambling problem or addiction, or at least an issue with spending a lot of money near Casino Niagara. Another issue is the failure, of course, to account. So this was the overriding concern expressed by her brother, that she hasn't kept good records. She hasn't really provided a good accounting of what she did with Mom's assets. And of course, that is one of the key duties of acting as a fiduciary, as a power of attorney, is to keep good records and accounts. And again, as Justice Greer mentioned, vouchers are essential. The issue of the gambling problem leads to another question about Emily's ability to continue acting as power of attorney. Is she actually able, does she have the capacity to continue acting? Is she able to discharge her duties? And that, I think, is going to be the overriding question that a court will look at is, okay, these acts all happened in the past. Can she be rehabilitated, so to speak? Can she actually discharge her duties effectively as a power of attorney in the future? And what steps is she going to take to make sure that she discharges those duties? So I think all of those factors the court will look at in determining whether she should be removed at this juncture or whether she can continue.
And Angelique, if the court or retired Justice Greer were to remove Emily or suspend her as an attorney for property, you think it would be a slam dunk to better call Saul and have Saul act as the replacement guardian of property, or is there someone else? And what factors do you think the court might consider in deciding who should take over?
I don't think it's necessarily a slam dunk that Saul will be the best suited. One of the factors the court will look at is of course, who was named, as Emily mentioned, who was named in the power of attorney document. The other factor, of course, will be the how close was the relationship between the incapable person and the person seeking to be appointed as guardian of property. That will be a key consideration the court will look at when making the decision. Will Saul be best positioned to act as a fiduciary? Will Saul be able to discharge the duties associated with acting as a guardian of property? I'm not sure we have the evidence about how well positioned he is to do that, to discharge those duties. Of course, another possibility is to appoint Saul as joint guardian of property along with Emily, and that was some of the comments we heard on the panel regarding Emily providing an accounting on a regular basis, showing Saul what's going on, making sure he's in the loop. So that sort of links in a way to a joint appointment as guardian of property. I'm not sure if this would really work at the end of the day unless they can seriously repair the relationship through Jordy's fine mediation skills. Whether there's a level of distrust, mistrust, hostility there that precludes them from acting jointly as guardians of property.
And thanks, Angelique. I'm going to turn the next question over to John Clegg. No coincidence when I asked him the question about what about the possibility of a corporate guardian of property? Is this something that a trust company might undertake and entertain?
Yeah, thanks for that, Archie. So certainly in a case like this one where we've got competing parties, I think a trust company is a good solution. Trust companies, of course, will keep everybody honest, and will also make sure that everything is done correctly, and we bring the knowledge and expertise to a case like this one. Just to reiterate, one of the most important factors that we've talked about today is record keeping. Trust companies are very, very good at keeping records, very good at getting all the vouchers that the court maybe require on a passing of accounts. So record keeping is what we've done and what we've done for many, many decades, as well as all the other services that go together with being a fiduciary. So in a case like this one, a solution may be, a corporate guardian could act, jointly with the party, with the children here. That could be a possibility. We could be an agent for attorneys, which is another one that's seldom overlooked. And I think in a lot of these cases, people usually, or I guess counsel sometimes will often go straight to court and look for a guardianship solution. I think sometimes we may want to look at more of an agency solution. It may be a less expensive option in terms of solving one of these cases. So record keeping is key, and then of course we bring all the other, a lot of the other good factors, which is neutrality, the investment management piece, the payroll services if there's caregivers involved. We just ensure that all the records are taken care of, and the one important factor is I can't say never because I'm sure there's case law out there that you could find, but trust companies aren't in the business of stealing money or borrowing money or forgetting where they put money. So we're accountable for what we do, and they have the backing of a big institutional organization behind them. So so this is certainly something a trust company could help with.
Thanks, John. And just before I leave you alone, what about the concept, and I'm not sure if Jordy was going there, about trying to make peace in suggesting a joint appointment of the trust company along with one or both of the warring SIBs as guardians of property. Is that something that the trust company might contemplate?
Yeah, we do get involved, and as I say, we get involved in some of these situations. It's a possibility, but I think the key component of this, as I said before, is if we're going the court route, then certainly we need a management plan that everybody can agree to. Because without a management plan that everybody's agreeable to, you're going to end up in a deadlock position. Also, so if we are acting in a situation like this too, we'd also want some sort of majority provision, whereby the trust company has the final say, so there's no sort of deadlock. Or we can go the agency route, and rather than having a management plan, we'd want some sort of minutes of settlement that lay out all the terms of the appointment, right down to the budget and basically accounting for what you're going to do on a yearly basis. So yeah, it's doable. Not in every case, because there's cases we're just to put a trust company in with as a joint guardian. Sometimes the circumstances just don't work because everybody just can't get along, and there's too much disagreement. But it can work as long as it's practical.
Thanks, John. I'm just going to turn now to David Lobl and ask and focus on questions about Saul the Nudnik's concerns about Emily acting as estate trustee for Mel, for their late father's estate. I understand from the fact pattern and from the discussions that Saul is less than enamored with the idea of allowing his sister Emily to continue to act as estate trustee. He bases his concerns, it would appear, on the fact that, according to Saul, she has messed up as acting as an attorney for property for mother, and therefore, on that basis, ought not to be allowed to act as the estate trustee for their father's estate. So one of the questions that I'm going to ask David to address is, would he, Saul, succeed in getting Emily removed as an estate trustee, and if so, at this juncture? So David, if you could speak to that.
Sure. So the starting point would be the Trustee Act, Section 37, which would allow a person with an interest in the deceased estate to bring an application to the court to seek the removal of an estate trustee. The issue that Saul will have in this case is, at the moment, he is not a beneficiary of mom's or of dad's estate, as everything went over to mom. So he may not be able to meet the test of having being a person interested in the estate. However, as we saw in the previous panel, Ms. Stam was talking about her interest in the estate on behalf of the minor, Saul's child. And Saul may want to notify the children's lawyer's office and get them involved, either to work together with them or as bringing an application as guardian of his son or daughter, I forget, estate to have the removal undertaken.
Assuming that the court figures out the standing issue, and assuming that anybody has standing to remove or to seek the order removing Emily as estate trustee of their late father's estate, what grounds need to be made out before such a removal order would be made, or a suspension order?
So there's basically 5 points that a court will make inquiries into or be guided by, principles that they'll be guided by when considering to remove an estate trustee. The first principle that they're guided by is that a court is not to lightly interfere with the testator's choice of trustee. So the court recognizes that the testator or testatrix made a choice in who he or she appointed as a estate trustee, and the court is going to try very hard not to amend that choice unless absolutely necessary. The second principle that a court will look at and be guided by is that the trustee's choice should not be removed except where it is clearly necessary to do so. So there needs to be clear evidence put to the court to satisfy the court as to that the trustee needs to be removed in the circumstances. The court's main guide should be the welfare of the beneficiaries of the estate, which would include the minors, unborn, and unascertained beneficiaries. And the court must find that allowing a trustee to continue will prevent the proper execution of the will or the trust, and that past misconduct is likely to continue such that the assets and interests of the beneficiaries will not be protected. So in this case where Emily's past misconduct will be viewed by the court as something that will continue on going forward. And as a result, the beneficiary's interest in the estate will not likely be protected in the circumstances. So, you know, in looking at this case and the factors that the court would look at on behalf, at least on behalf of the minor, and coming after whether Emily should continue, the court will likely look at the conduct of Emily, whether or not she's been self-dealing in some of the assets, the gifting, whether that was appropriate in the circumstances and potentially defeating interests of beneficiaries. And it is more likely than not, in my view, that the court would take steps to remove and replace Emily in the circumstances.
Just as a follow-up, David, if the court were inclined to appoint an estate trustee during litigation, instead of removing her, Emily, as an estate trustee, given if there's no will challenge, does the court have the jurisdiction, do you think, to make such an order, and what's the likelihood?
So I do believe that a court does have jurisdiction to do so. Madam Justice Greer has referred this morning to the Penna estate, which she presided over. And in that case, using Section 28 of the Estates Act, where there was no will challenge, Madam Justice Greer did remove or appoint an ETDL, estate trustee during litigation, to preserve and protect the assets of the estate while the litigation was ongoing. The one thing in this case where an ETDL may or may not be useful is that the role of an ETDL is essentially the same as an estate trustee. However, the ETDL is not permitted to make any distributions of the estate. So the ETDL is there to, as I said, the phraseology that we always use is to preserve and protect the assets. So to gather in, it may be necessary in this case for an ETDL to seek or make claims against Emily for the return of assets and maybe other third parties, if necessary, to gather in all of the assets of the estate, and then the ETDL will preserve and protect those assets until there's a further court order. But I do believe that the court does have jurisdiction. There are some people who don't agree with that, but I do believe in Section 28 of the Estates Act there is specific allowance to order an ETDL when there is not a will challenge.
John, I'll put you on the spot if I could. You've touched on it in some of your earlier comments. Just if you could just spend a few seconds that we have on benefits and perhaps negatives of having a corporate estate trustee during litigation appointed, assuming that the court was inclined to make such an order in this case.
Yeah, so I think in terms of the negatives, I think what we always look at every case as a business model. Really, it's you look at the estate and said, is there any value an estate trustee during litigation, particularly a corporate one, can bring to this case? And the reality is, if it's an estate that has diminished assets, or there's a possibility of the estate being bankrupt, or like the Penna case, if there's assets that you have to get back, and they've gone to charities or organizations where the bank may not necessarily want to put its reputation at risk, we may not want to take on those types of cases. But generally, we can act in most cases. So in terms of the benefits, there's a number of benefits. A lot of those are the same as I mentioned when we act as a guardian. It's corporate. They bring neutrality. They can let everybody that's involved. We can get a handle on what's in the estate, so that when there is a resolution, people know how they're going to divide up the pie. We bring the record-keeping components. We bring the all of the knowledge that goes with protecting and preserving assets, and they could be it could be as simple as stocks and securities at the bank, or it could be a business. We never know what we're going to get involved in. There's a lot of expertise there with the trust companies in terms of assets and what we do. So neutral. But also we don't need to bond. There's no bonding requirement for a trust company. So that's a big cost saving to clients, and also we don't require any sort of indemnity insurance either. So there's a lot of pluses there. Again, as long as it makes financial sense to bring in a corporate entity to a dispute.
I think we are coming to an end. I want to thank all the panelists and, of course, the organizers and Charles for putting up with me coming at the last second. But I don't know if there's questions that will be put later on at the end. All right. Well, thank you very much. We'll conclude with that. And I have no idea what's next.